Okay, again, so guardianship busting the myths. Before we actually begin this webinar, I would like to acknowledge the traditional custodians of the land and pay our respects to elders past and present, and also extend that respect to any Aboriginal or Torres Strait Islander people listening today. Just for introductions, my name is Andrew Marius. I'm a lawyer at Legal Aid. I currently work in the community legal education branch at Legal Aid, but my background at Legal Aid has been in family law and crime. And we're joined today by Jessica Butts from the New South Wales Trustee and Guardian. So I'll ask you to introduce yourself, Jessica, please.
Sure. I'm Jess. I'm from the New South Wales Trustee and Guardian, and I work in the Public Guardians Information and Support team. I know that sounds really confusing, but I'll talk more about how we're all related soon. Before I worked at the Public Guardian, I worked in a community setting with people with disability and mental illness, and I've been at the Public Guardian for around 4.5 years now.
Mm-hmm. Oh, okay. Thank you, Jessica. And finally, I'd also like to mention that there's a handout on the control panel, including a PDF presentation of the presentation that we're using today. So please feel free to download it and follow along. And the final bit of housekeeping, not to sound like a lawyer, but a bit of a disclaimer, that today's presentation is just for legal information only, not legal advice. Of course, if you have a specific legal question about guardianship, or any other legal question for that matter, please call Law Access on 1300 888 529 and someone will attend to your call. So thank you. All right, so for today, we will look at the contents, and I would just ask Jessica just to run through what we'll be talking about today.
Yep, so today there's quite a lot of information to get through, but just to start off with, I'm going to introduce some concepts about decision making and capacity. We'll talk about what is guardianship. We'll talk about the different functions and roles of the trustee, the public guardian, and the Guardianship Division of NCAT. We'll talk about when you might need to apply for guardianship, the different areas guardians can make decisions in. I will talk about the public guardian, just to give some information about us as a team from the New South Wales Trustee and Guardian. And I'll also talk a bit at the end about alternatives to guardianship.
Okay, all right. Well, before we just, again, get into it, just to get a sense of the background knowledge of the audience, I'll start with a poll. So there should be, just if we just possible just to type in your in the questions poll. So who in the audience supports people who have an appointed guardian or a trustee appointed? If you have background or answered any of those, please feel free to type that in the chat box now. Yeah. So we have, we have a wide range. Yes, we have people that do work, we have people that do not work, but are interested. Yeah. So it's a bit of a spectrum. People that do work, but people that don't work but are interested to learn more. Okay, Jessica, I'll just ask you to run through this slide, please.
Sure. So I just wanted to talk a bit at the beginning about what we refer to as the decision-making spectrum and also capacity, because when we talk about guardianship, it often usually starts with a conversation about capacity. So with decision-making, it's something that a lot of us do every day. A lot of us don't really think much about it. I think if I asked all of you to tell me how many decisions you've made up to this point today, I think there would be some really big numbers thrown around. It's probably something you would do either in that independent part of the spectrum or the supported part. So you might be making decisions yourself, you might be supporting someone or be supported to make a decision. There might also be some co-decision making happening. So it's something that we all do. It's also something we do in our work where we sometimes support or empower people to make decisions for themselves. We often kind of fluctuate between making those decisions in the front end of that spectrum of that graphic. So we can go back and forwards depending on the decision, depending on a lot of things. We can kind of, our decision making might fluctuate. It's important to think of it like that because it also acknowledges that people with disability can practice decision making and can also kind of move back and forward on that spectrum. Up the end of the spectrum is the substitute end. So that's where guardianship lives. I'll get into the nitty-gritty of guardianship after this little part. But I just wanted to kind of introduce this decision-making spectrum as a way to think about how we all make decisions, regardless of the presence of disability.
So on that, how does that tie into this slide?
Yeah, on that. So this is some work that's produced by the Cognitive Decline Partnership Centre. They were doing some work around supported decision-making in the aged care space. So they've developed this graphic to kind of explain the processes involved in making decisions. So if we look at the graphic, we can see that there's quite a lot to making a decision. So I've got to understand the information, retain the information for long enough to make choices. We've got to weigh up all of that information as well, and then communicate that choice in some way. Our ability or capacity, so you'll often hear me say the word capacity in the next hour, depends on a lot of things. It depends on our ability to do either one of those steps. It depends on the environment we're in. It can depend on illness. It can depend on the decision itself, and it can also depend on other stresses. But if we look at it all together, there's actually quite a bit involved in making decisions. A simple example about how we can sometimes struggle to make decisions, or we have to make decisions in different circumstances might be if you're going to meet a friend at a cafe, you're rushed, you're really hungry, you're really tired, the cafe is really noisy, you've just sat down, and then a waiter has rushed over and asked what you want. So at that point, you might not be ready to make that decision. You've got to read the menu and understand it. You've got to be able to weigh up the choices on the menu and then communicate your decision in some way. So you might make that decision independently. You might want time to make that decision. Or you might ask for support from your friend around what you want, or you might do the old, I'll have what she's having. So it is, even for simple decisions, if we put that all together and look at the circumstances around making decisions, there's actually a lot to it. Thanks, Andy.
No. So, to bust the myths, we have myth one: a guardian is like a carer, so I don't need to have anything formal to have one.
So these myths are based on some of the common questions we get asked at the Information and Support Unit at the Public Guardian. So some people will call and say, do I need to do anything to have a guardian? The answer is yes, it is a formal legal appointment. There is a piece of legislation called the Guardianship Act, which says, what is guardianship, and that people are appointed with that authority under the Act. There's also sometimes a bit of a misunderstanding about who it relates to. So people often use the word guardian in the context of children, so being a children's guardian. In the context we're using it in today, and when we're talking about the Guardianship Act, it does relate to adults. It is limited by decision-making area, and so we'll go into that a little bit later, but it is limited. And it also differs in each state. So each state has their own guardianship legislation. But it essentially is making a decision on behalf of somebody else. So if Andrew was my guardian, he would be making a decision for me when I couldn't make that decision. So that's kind of a quick definition, if you like, of what is a guardian.
Okay. Just take us through myth number 2, please.
Yeah, so myth number 2. So sometimes we get phone calls asking if someone can make a referral to our service. With guardianship, it's not a referral pathway in that sense. And I have chosen to start this way with this type of appointment or this way of appointing a guardian, because I'm assuming that a lot of people who are watching us today maybe support people who don't have capacity. So in New South Wales, there are 2 ways you can appoint a guardian. There's one way when the person doesn't have capacity, and then there's a different way when the person does have capacity. So I've started today with that pathway when the person doesn't have capacity, because I thought it would be most relevant to the people watching us today. But as I was saying, it's not a referral pathway when the person doesn't have capacity and a guardian is needed. An application needs to be made to the Guardianship Division of NCAT. So the Guardianship Division of NCAT is a body that makes and reviews guardianship and financial management orders. They also do a couple of other things with that other way of making guardians where you have capacity. They can give one-off consent for medical treatment. They can also do things like review decisions made by the public guardian. But when a person doesn't have capacity, an application needs to be made to NCAT. With the New South Wales Trustee and Guardian, and I acknowledge this is really confusing because we all have guardian in our name, but we have different functions. So you've got the Guardianship Division of NCAT, then the New South Wales Trustee and Guardian. So the New South Wales Trustee and Guardian has the New South Wales Trustee and also the public guardian. So it's important to note here that guardianship legislation is different to the legislation around trustee. So if we think of guardianship as health and lifestyle, and then trustee as money. So there's different pieces of legislation for those different functions, but we both come under the banner of the New South Wales Trustee and Guardian. So once an application is made to NCAT, they can decide whether to appoint a guardian or not. And that flows nicely into our next slide, Andrew, actually.
Smooth transition.
Which is what happens once an application is made. So a lot of people kind of think that once they make an application, and I acknowledge there's people here today who've probably been involved in this process before, but some people think that once you've made an application, it's automatic. There's automatically a guardian appointed. But for those of you who have been involved in this process, you'll know that there's a hearing. So with the hearing, there's a panel, so a tribunal, and they will decide a couple of things. So they will decide if the person can make their own decision with or without support. That's really a question of the person's capacity. So whether that person is able to make that decision. They'll also consider if there's a need. So when we talk about a need, we say that there has to be a current decision. So NCAT isn't in the practice of appointing guardians just in case. There has to be a current need. And there's a really important reason for that. And that is that decision making is a right. Like I said at the beginning, it's something that we kind of don't think too much about in our day-to-day. but it is something that we have a right to do. So appointing a guardian is effectively taking away that person's right to make that decision. So that's why there needs to be a current need for a decision to be made. There needs to be a current decision. And they'll also look at who should be appointed to be the guardian and for how long. So this is a really important difference in this way of appointing guardians as opposed to the other way, which I'll get to after this. When appointments are made by NCAT, they're time limited, and they decide who should be appointed. So they'll look at, you know, who's available, who's there, the circumstances surrounding the person, and then appoint a person, and then they'll specify for how long that appointment will be. In the first instance, if it's the person's first guardian, it will usually be a year. And if it's after that, there'll be a review process. Sometimes there's no review process. So NCAT can decide to make what's called a non-reviewable order, which means that that order is not reviewed. That might be made in a case where the tribunal think once these decisions are made by the guardian, we don't think this person will need a guardian anymore. We think these decisions can be made in a year, this situation maybe can settle, and then that person won't need a guardian anymore. So we're not going to have an automatic review process. Some orders do have that automatic review process. If it is a non-reviewable order, it doesn't mean though that if you're involved in a matter like that, you can't apply to NCAT to have a review happen. I acknowledge that these procedures are confusing and they all really depend on the circumstance. NCAT does have an information service that you can call and ask questions about what happens at a hearing. They've got some really great resources on their website as well, which you can access. Yeah, but with applications, I will say it's good that if you are involved in making applications, that if there are family members or friends who do have involvement with the person, to be mindful of whether they also need to be involved in that process. With NCAT appointed guardians, as I said, it's not automatic. After that hearing, they might decide, actually, this person doesn't need a guardian. So it's not an automatic thing. They decide it based on the evidence, based on everything, all the factors of the situation that they need to consider. And they will make that decision following the hearing. And that should take us to our next one, I think, Andrew.
Yeah. Yep, so myth number 4.
Yeah, so myth number 4. So sometimes we get asked if applications are made to NCAT, that means that the public guardian or the New South Wales trustee will be appointed. It isn't necessarily the case. So with NCAT appointed guardians, they will consider if there's a private person who can be appointed before they appoint the public guardian or the trustee. So, and I'll just clarify as well, today we are really zooming in on that health and lifestyle decision making, which is guardianship, not so much on the financial, which is the New South Wales trustee side of things. I will mention it from time to time, but we're really honing in on that health and lifestyle aspect. So they will consider if there's a private person. So when I say private person, I don't necessarily mean a doctor or a professional. I mean a family member or a friend, someone with a personality that's compatible to the person. There's no conflict of interest and they've got a close and continuing relationship. They also need to be at the hearing. So if you are making applications and you know that the person has some family who are quite connected and involved in the person's life, it's good to involve them from the beginning of that process so they can, if they want to, be at the hearing and maybe be considered to be a private guardian. It's preferable to have a private person appointed ahead of the public guardian, because obviously that they have a close relationship. The person and the private guardian, they know each other. The private guardian knows their values, their wishes for their life, their preferences, and also a lot of their background and history, and knows them as a person above. That's a really great relationship and a good thing to have when being a private guardian. It's also good to if you are involving people in that application process, or you know that there are family members who are making an application on behalf of another person, that private person is really well resourced. So we sometimes get asked, or we might get a phone call from a private guardian saying that they didn't actually know what was involved in this guardianship thing when they were appointed. So it's really important that if they are considering putting themselves forward to be considered as a guardian, that they understand what it does mean. So they can always give us a call to talk about it. You can feel free to pass on our contact details, which are at the end of the slide deck, and that you resource that person so they know what they're undertaking as a guardian. NCAT can, if there are no private people who can be considered, sometimes there are private people, but maybe they don't have all those things in that list there. Maybe they have a conflict of interest. Maybe there's been some conflict in the past between that person and the person who's saying, I want to be the guardian. Or maybe there's some conflict between family members, which mean it would make it really hard for that private person to be the guardian. NCAT can then decide to appoint the public guardian as the guardian of last resort. Thanks, Andrew.
No, you're right. Yep. So myth number 5.
So now I'm going to switch over a little bit and just talk about that other way that guardians can be appointed in New South Wales. So we've talked about the way they can be appointed if they don't have capacity. So that was that making an application, having a hearing, the tribunal makes a decision, and then a guardian is appointed or not. That other way is when people with capacity can appoint someone for the future for a time when they need one. A lot of the time I get asked or am talking to someone and they say, but I'm the power of attorney. That means I can make those health and lifestyle decisions. In New South Wales, it's 2 different roles. So you've got a power of attorney, which is those financial decisions. A lot of people know power of attorney because if you're making a really big life decision, like buying a house or something like that, having kids, you might go and do your will. It's really common to also do your power of attorney at the same time. But enduring guardian, appointing an enduring guardian is maybe not as common. So a lot of people know power of attorney. A lot of people might have one. When I'm talking to people and we're face to face in a room, I might ask them to put their hands up and say, who has an enduring guardian? Who has appointed one? And overwhelmingly, more people put their hand up for power of attorney than they do for enduring guardian. So a lot of us know what a power of attorney is, but some of us don't know that a power of attorney is a different role to that guardianship role, which is again the health and lifestyle decisions. It is also confusing because, as I said earlier, different states have different arrangements, different legislation. An attorney can mean a different thing in a different state. But in New South Wales, enduring guardian is a different role to that power of attorney role. So an enduring guardian makes those health and lifestyle decisions. You can appoint one when you have capacity for a time in the future when you might need one. That's not to say that'll always happen. You know, we don't know what life is going to hold in the future, but it's something you can do to maybe avoid those NCAT processes, and is something that is your just in case mechanism. You can appoint more than one person, so you can appoint a couple of people if you like. You can tell them how you want them to make decisions. So you can say, I want you to make decisions together, all together. You all have to agree, which is called jointly. You can say you can either all agree or make different decisions separately. That's called jointly and severally. Or you can say, if I was appointing Andrew as my guardian, and let's just say my brother is also my guardian, I might say, Andrew's going to make my decisions about where I live, and my brother will make my decisions about my healthcare. That's called severally. So you can say how you would like them to make decisions. You can give directions, but again, you can't appoint a paid professional. So that means you can't be paid to provide guardianship services. So I hope that dispels that myth that in New South Wales, enduring guardianship is really about that health and lifestyle. Power of attorney is about the financial side of things. It doesn't mean, though, that you might not appoint one person as both. It just means that if you're going to a solicitor, if you're going to the New South Wales Trustee and Guardian to make these arrangements, essentially you're looking at maybe two different pieces of paper. And it also means you can appoint different people for different things. I will say it's a good process to do because as much as some of us in our workplace or whatever we might do are maybe used to having some conversations about the future, they might be very uncomfortable. And they might be sometimes overwhelming, or they might be hard conversations to have. Undertaking these processes means that we can have those conversations with our family and friends. We can tell them what we want now when we have the ability to tell them. And we can also appoint people to make those decisions who maybe share our values or have a really intimate knowledge of our values or what decisions we would make if we could. So we can appoint people who can make the best decisions for us for a time when we might need it. Thanks, Andrew.
Okay. Yep, myth number 6.
So I'm just going to, now that we've talked about the two different processes by which a guardian can be appointed, I'm just going to, I guess, acknowledge the commonalities. So sometimes people may think that there's a difference in your authority depending on how you're appointed. If I appointed, or let's just say I was appointed, oh no, I'll scrap that example. If someone is appointed as a guardian for accommodation, so where someone might live, and the public guardian is also appointed with that same function but for a different person, they have the same legal authority. So all guardians share limitations, and also depending on what functions you have the same authority. So guardians can't make decisions that are contrary to the law. No guardian can make a will or vote or consent to marriage on someone's behalf. No guardian can can write or override your advanced care directives. I will just talk to overriding objections to treatment because that flows into our next slide where I'll talk about different decision-making areas and we'll touch on those, how guardianship is limited, because guardians can't override objections to medical and dental treatment. However, there is a function that might enable a guardian to do that. So that one's a little bit confusing, but there are general limitations to being a guardian that we all share, and it doesn't really matter how a guardian is appointed, you are a guardian, and that is the same. It doesn't matter on that bit on the front, enduring, private or public, a guardian is a guardian. Thanks.
No, you're right. Yep, so myth number 7.
So guardianship is limited, as I've said a couple of times. And when we think back to that spectrum at the beginning of the webinar, and we think of those 3 different areas, the independent, supported and substitute, the end where guardianship lives, the substitute end, it doesn't mean that a guardian takes over all aspects or all decision making for a person. Guardianship is limited to decision-making areas. We call them functions, but they are areas that they're quite broad, as you can see, where guardians can make decisions. The most common functions or decision-making areas are accommodation, medical and dental consent, healthcare, and services. So if you're going to a solicitor or the New South Wales Trustee and Guardian and you're making an enduring guardian document, you'll find that generally those are the 4 that are included. So accommodation is where you live. Healthcare are those sorts of allied health services that you might receive. Services could be anything from Meals on Wheels to your specific disability support services or aged care related support services. And medical and dental consent is consenting to medical and dental treatment. The functions or decision-making areas depend on the person's circumstances and situation. So if a guardianship order is made through NCAT, so NCAT have decided this person needs a guardian, they can decide and give the guardian their decision-making functions, and that depends on what decisions need to be made. So it might be that if a matter has gone to NCAT and the decisions that have come up are that, you know, the person isn't able to make a decision about where they live or some healthcare related decisions, then NCAT can only appoint the guardian or will only appoint the guardian with those 2 functions. So it's not automatically that a guardian gets all of the functions. It's limited to that person's circumstances. There are more functions you can see on that slide because, as I said, they are tailored to what decisions are needed for that person. Accommodation authorised others. That is one where the guardian has the authority to override a person's objections to their accommodation by authorising the police or ambulance to take that person to an approved accommodation or bring them back if they leave. Overriding consent to treatment is what I mentioned in the last slide. So that is a function that a guardian can have in very, very select circumstances. Legal and advocacy. So a guardian might have the advocacy function. If they need to do some particular advocacy work, you might find that around some NDIS matters. Legal gives the guardian the authority to consent to the person receiving legal services. So it isn't the same as instructing a lawyer on behalf of the person. It's about consenting to those services. And access is decisions about who the person should see or shouldn't see. You find access appearing more in cases where there may be a bit of family conflict or some complex relationships that when the person Perhaps the person is, some people are not allowing that person to see who they want to see, or maybe the person is having some contact with someone that is impacting negatively on their disability or their illness or their life. So that's access. And then restrictive practices, which again is a more restrictive function that allows a guardian to consent to the use of restrictive practices for people. So those are those practices that we might see in the disability space around things like chemical restraint or physical restraint, those sorts of things. So the decision-making areas depend on what the person's needs are, where those decisions need to be made. Let's just say that Andrew was appointed as a guardian. He was given accommodation and services. And those are the decisions that he started to make as a guardian after being appointed. Midway through his appointment, he starts to kind of see a bit more things come to light, where he might say, actually, I need to make some more decisions in different areas because there's some more things popping up that I didn't know about at the initial hearing. So either in the review, or he can apply to NCAT for an early review. He might say, I actually need healthcare and I actually also need advocacy because some other things have popped up. But however, let's just say the accommodation is sorted. The accommodation is settled, that person no longer needs accommodation decisions. During the life of that order, Andrew's made those decisions, the person really likes where they're living now, and there's no really foreseeable accommodation decisions to be made. The tribunal might then say, okay, we're going to take away accommodation, but we're going to add healthcare and advocacy, so that Andrew now has the authority to make the decisions he now needs to make as the situation has changed. We might move on to the next one, I think. That's okay.
Yeah, myth number 8.
So myth number 8, people with disability or dementia need a guardian. So as I've been talking, I hope I've conveyed some of the situations where a guardian might be needed. Sometimes we do get asked, or we do get a phone call, and it's usually out of concern. I want to say that it's usually that a service provider or a family member is worried about the person, and it might be that they feel the person needs a guardian because they have a disability. It isn't always the case. It is a very limited thing, and it's also a very restrictive thing on a person. So it's only really needed where there's a decision. So as I said, it's orders made by NCAT are not really a just in case mechanism. There needs to be, if there is a need for a guardian, there needs to be some sort of evidence that a person is objecting to a decision and is also at risk. So if that's not really the case, there might not be a reason to apply. It also might be the case that there are other things that could be tried before applying for guardianship. So I'll talk a bit later about those alternatives, but it might be that some other things are tried first before an application is made. If there's no legal requirement for a decision, so if there are some cases where there are legal requirements for a decision like medical and dental consent or restrictive practices, if that's not the case, there's not necessarily a need. If there's no conflict and there are other options available, then it might not be the case that an application is needed purely based on the fact that that person has a disability. There is a difference between an appointed guardian and an advocate. So guardians do advocate, that's definitely something they do, but it might be that alternatives are looked at where the person could have an advocate involved for that issue, that particular issue that you might be concerned about or a family member might be concerned about, rather than going through that legal process and having that restriction placed on the person's decision making. Thanks, Andrew.
And just information about the public guardian?
Yeah, so I just wanted to give a bit of a snapshot about the public guardian, because I know probably some people watching us today work with people who have the public guardian appointed or have had some contact with our office. The public guardian represents approximately 2,900 people. Most people I ask, or I put that number to, think that's pretty small. And I would agree, it's pretty small. And I think that really speaks to the public guardian being the guardian of last resort, and also that sort of there's that review process in those guardianship orders. So it might be that someone has the public guardian for a year, and then the following year they might be appointed with a private guardian, or they might not have a guardian anymore. So that number, most people tend to think, oh, that's pretty small, and I would agree. We're about 90 staff across 3 locations. We do have our information and support team, which is where I'm from. We are happy to take any questions at all about guardianship. So on the contact details at the end of the presentation, you'll see our number. Feel free to give us a call. We're happy to talk to people if they are thinking of making an application, and we can talk you through the process, but also be that kind of virtual colleague and talk through the matter and see what, you know, what some likelihoods might be, or what kind of maybe some next steps are. Our information support team also has a private guardian support unit, which provides support for about 3,400 private and enduring guardians. All our decisions are reviewable, so all public guardian decisions are reviewable, and as I've said, we're the guardian of last resort. Thanks. And I just wanted to, just off the back of that, about talking about us at the public guardian, I just wanted to talk about how we make decisions, because some people tend to ask us that, is, you know, how do you go about making a decision for someone else? In the Guardianship Act, there are the guardianship principles which guardians need to make their decisions while weighing the decision against those principles. So guardians at the public guardian do that. They weigh the decision against the guardianship principles. Usually when we make a decision, you'll often find guardianship comes about at a point of transition in a person's life. So usually it might be, well, not usually, but sometimes it might be that a person's gone into hospital, they're unable to go home safely, and we receive a proposal or a proposed decision, maybe from the hospital social worker, about some alternative accommodation for that person. We would weigh that decision with the evidence against the principles. We talk to the person, we talk to those people around them as well and get their views on the decision. And we will also do a lot of other sort of investigation. So it is quite an in-depth process because we are trying to make the best decision for that person. As I said, our decisions are reviewable. That is a difference between the public guardian and private and enduring guardians. If you, as a service provider or a community worker or whatever your role is, if you are working with someone who has the public guardian appointed and they're not happy with the decision, they can apply for a review. If someone isn't happy with decisions being made by a private guardian or an enduring guardian, the process for that is to go back to NCAT to have those orders reviewed. So the public guardian doesn't necessarily oversee private or enduring guardians. We're more an information service and a support service for those guardians. But if you are concerned, or the person is concerned with how their guardian is making decisions or the decisions they're making, they can go back to NCAT to apply for a review. Because their decisions, we're not able to review those decisions. Thanks.
So alternatives to guardianship and planning ahead.
Yeah, so I just wanted to talk in our last couple of minutes about, before we get into some questions, just about some alternatives to guardianship and planning ahead. So as I've said the whole way through, guardianship, and especially the public guardian, is a last resort option. So it is really important to consider what could happen before that point, before making those applications. So supported decision making is something that can be considered an alternative to guardianship. It really is about mitigating risks, building that person's network, and also that practicing of decision making, so that ability around decision making, and it really empowers the person to retain those decision making rights. It's something that has, there's a bit of a movement behind it now. A few years ago, we kind of saw it more in the disability space, but very much we're seeing it now in the aged care space and the mental health space. So it really is something that there's a lot of enthusiasm for. And I know a lot of you out there have probably already heard of it and are probably already doing it. Resolving conflict. So the public guardian is often appointed when there is conflict. The public guardian is not a professional mediator, so it might be worth it to maybe seek mediation before applying for guardianship, because we won't necessarily resolve that conflict. A guardian only represents the person at the centre of it all. So we won't necessarily go in and resolve the conflict around that person. So there are mediation services out there. Relationships Australia offer elder-specific mediation, and there's also the community justice centres that do free mediation. So that might be an alternative if that's what's happening around that person. There are also a few nominee arrangements that already exist in different areas that mean that it isn't really necessary for an appointed guardian. So a lot of people in the NDIS space might know about NDIS nominees. In the aged care space, there are aged care nominees. And of course, you've got things like Centrelink nominees in that financial space as well. So those sorts of nominee arrangements might be something to consider before going through that legal process. And also person responsible, which actually takes us to our next slide.
Yeah.
So person responsible, we are probably, all of us here today are probably all someone's person responsible, and probably all have a person responsible. So a lot of people think of a person responsible as next of kin. Person responsible is the term used in the Guardianship Act to define the person who can consent to medical and dental treatment. So if a person needs consent for a particular treatment, and you might think, oh, we need a guardian for that, it isn't always necessary. So there is a hierarchy that the medical practitioner will go through to identify who that person responsible is. At the top of the hierarchy is a guardian with that function, the medical and dental consent function. The next one is a spouse or partner. Then there's an unpaid carer or a close relative or friend. So if there is no guardian, the doctor can go to the next person on that list. So it doesn't mean there has to be a guardian. And if those are the only decisions that need to be made, it might not be necessary to have a guardian. It might be that your person responsible can make those decisions for you. It is also sometimes like attorney. It's a misunderstood term. It does only relate to medical and dental treatment. It doesn't relate to other areas of the person's life.
Okay.
And our last one, I think, is planning ahead. So what I've mentioned in terms of power of attorney, enduring guardian, you can also make a will, and you can also make an advanced care directive. An advanced care directive, often described as a living will, is a statement about the medical treatment you would want in the future, but it needs to be based on your current circumstances and can only be made when you have capacity. So going and talking to your family, going and talking to the New South Wales trustee or a solicitor about how to make those planning ahead documents might be a way that you avoid those NCAT processes. And again, having those tricky but uncomfortable conversations, they can be hard. And sometimes we might have them all the time in our day-to-day work, but always harder with the people you know and love. But if I can encourage you all to open up about those things, they are really valuable conversations to have. And it means that in the future, you might not need to go down that NCAT route. So I think the next part of it, we did have a couple of case studies, but Andrew, what do you think? Should we move on to those?
We can briefly go through the case studies. Please feel free to leave at 11:30, but we can go over for a little bit just to take your questions if Jessica is happy to stay
of course.
on for a bit more.
Yeah.
There we are.
Yep.
So happy to go through these case studies and possibly at 11:30 we'll have a short window for questions. So please continue, Jessica.
Yeah. So we did just have a couple of case studies here. The first one, we've got Norma. She's an 82-year-old woman with the beginning stages of dementia who lives in her own home. She receives a visit from a care service once a fortnight to help with cleaning and goes out once a week to a local seniors group. So Norma's been admitted to hospital. She had a fall at home and has broken her wrist. She'll need some follow-up care and rehab as well. Norma's daughter has asked the hospital social worker to make an application for guardianship and financial management based on the fact that Norma's condition will continue to decline. She thinks that she'll need a decision maker in the future. Norma's daughter is worried about her mother's safety at home. So we did have a question after that.
We had a poll question, but possibly for the sake of time, we might just go straight to the source. Jessica, would you, in your role, support this application? And the second question is, bear with me, and what would you consider to support your answer?
Yep. So if someone were to call me with this scenario, and it sometimes does happen, I must say they're not based on real people, they're more based on my experience of the calls that I get. I would probably talk to Norma's daughter or the social worker about some alternatives for Norma. At this point, I probably wouldn't support an application for guardianship. Norma might be at the beginning stages of dementia. She still might have capacity to make those planning ahead arrangements. And also she has some services. It might be that she gets an increase in those services to help her at home. It might be that she has a community nurse come out to help her do her rehab at home or that sort of thing, and help with the follow-up care. And it might be that there are some other things to consider here rather than making an application for guardianship.
Okay, and then on to the second case study. So we will move through the slides.
So the second one is about a young guy called Paolo. So Paolo is 33, he lives at home with his family. Paolo's got some really significant disabilities, but he's very social, he's outgoing, and he's got really strong connections with his workers and friends at his day program. Paolo wants to move out of home, and he's talked about this with his workers, and his workers have also brought it up at his individual planning meetings with family and his coordinator. Paolo's family are really worried about Paolo moving out and are not really supportive of this goal. They've been asking Paolo's workers not to talk about it with Paolo, and Paolo's workers have noticed some changes in Paolo, that he's a bit more withdrawn and that sometimes he's been a bit upset at day program. When they've commented on this to the family have said that they're actually thinking of changing his service. So when I might get a call similar to this, I think there are probably some things that Paolo and his family could do before applying for guardianship. But it is an example where if things don't resolve, if they're unable to resolve that situation, then a guardian may be needed down the track. So if Paolo's family, through some sort of mediation or some sort of supportive conversations, weren't able to come to an understanding of this decision, or if Paolo was to become increasingly unwell, or his condition was to worsen, or anything like that, that it might be that an application is made sometime in the future to help make that decision about whether Paolo should move or not. So it might be the case that an application is needed sometime if those things weren't resolved. So we can see that if Paolo's family are thinking of changing the service provider, is that in Paolo's best interests? If Paolo really wants to move out, and through working with his cause, if there are services out there that could support Paolo to live out of home, could his family kind of get on board with that and I guess work through some of that worry about him living away from home? If they were able to do all of that without the presence of a guardian, that would be fantastic. But if that sort of didn't resolve, and the conflict worsened and Paolo's conditions worsened and that sort of thing, then it might be that a guardian is looked at in the future.
Okay. Just before we get to the questions, again, I do stress that this webinar is being recorded. It will be uploaded to YouTube afterwards for your review, and you can review the slides via the handout. But Jessica, just to, before we move to the questions, what are the ways that people can contact you for further questions or further advice?
Yep, so just that number there, the information and support branch, or the private guardian support unit number. Either of those numbers, we're one and the same team. So feel free to give that private guardian support unit number out to family members, or people in the community you work with who are guardians, or give us a call if you're a guardian yourself. And yeah, either of those numbers are good.
Okay, brilliant. So as we move to questions, for the next moments, I had a question earlier. What is the process of ending a guardianship order, especially like if it's voluntarily entered into?
Okay, so if you were an enduring guardianship, so you've
possibly,
yeah. So if you've appointed an enduring guardian and you actually think, I want to change that, or I don't want that person to be my guardian anymore, or actually I don't want an enduring guardianship arrangement, while you have capacity, you can revoke it. So while you have capacity, you can go through that process of revoking it. There's actually some forms on our website that you can access to do that. Also, while you have capacity, you can change it. If I've decided, actually, I don't want Andrew to be my enduring guardian anymore, I'm going to make a new enduring guardianship arrangement and appoint my brother rather than Andrew. So while I've got capacity, I can change those arrangements.
Well, on that point, and it may have been covered, but just to reaffirm, what happens if there is a conflict between a guardian and a power of attorney in such areas as accommodation or finances?
Yeah, sometimes that does happen, and it's a really important thing to think about when you're making those arrangements for yourself, is that those two roles, as much as they're separate, they do need to work together. If the conflict is impacting on the decisions that are made, so where just it gets to a point where the two people can't work through that conflict to make decisions for the person they're appointed for, it might be that it goes back to NCAT for a review.
Okay.
Yeah.
Again, might have been covered, but if, and please feel free to type through your questions. If a person is believed to have an onset of dementia-like symptoms, so their memory does come and go, is it still appropriate to execute an enduring power of attorney at the time the person understands the nature of what they are consenting to?
Yeah, so when a person does make those arrangements, they do need to have capacity. If they are in those early stages of dementia, it might be that they go to their doctor and their doctor is able to provide an assessment of whether they can execute those arrangements or not. So if there's a question about capacity, and as a solicitor or as someone who is executing those documents, you're worried about that, it might be that they go back to their doctor and get an assessment done before they execute those documents.
Okay, brilliant. Does the PG, excuse my acronyms, provide any formal supported decision making, or can NCAT appoint someone to provide decision support to a PWD who needs it lifelong?
Yeah, unfortunately, supported decision making isn't legislated, and the public guardian doesn't have that sort of function. It has been recommended in a Law Reform Commission's report on the Guardianship Act. They reviewed the Act, and supported decision making did really feature in their recommendations, but it's not a legislated thing. So supported decision making is still largely in those informal networks or those service providers, family, friends, those sorts of networks. The PG unfortunately can't be appointed to provide supported decision making.
Okay, just a couple more, and I should stress, that the law access number on the previous slide, there is an amendment to it, my apologies, just the law access number is 1300 88529, that's 1300 88529 if you have any further inquiries or questions. Just how, if at all, does a guardian or guardianship order interact with the legal process of having a tutor appointed?
So it is different. Yeah, so a guardian is quite different to a tutor. When I talked about that legal function, it is guardianship and their involvement in those sorts of legal proceedings is more to consent to that person receiving legal services. So the public guardian or a guardian can't be appointed, the public guardian can't be appointed as a tutor for someone. And yeah, it's they're quite different processes. I imagine if there was a circumstance where someone did have a guardian for their health and lifestyle decisions, but had some matters in court and also had a tutor, then if the guardian needed information on what was happening in court, what the outcomes of those proceedings were and how that might factor into their decision making. So as you can understand, guardians need lots of information to make decisions. They might talk to people, so they might talk to that person, they might talk to the legal service, but the functions are quite different. Yeah.
And again, apologies if we've missed your questions. There are, please contact. I'll have one more question, but if we do not answer your question, please feel free to contact us through the contacts on the contact slide to get legal advice or get an answer to your question. Just finally, Jess, in Paolo's case study, if all other options are not viable, would the support service be in a position to facilitate a guardianship application?
Yes. Yeah. So it's actually anyone, and it's a rather important thing I should have mentioned at the very beginning. So thank you to who wrote that question, because you've pulled me up. Anyone with a concern for someone can make an application. So whether you're a service provider, whether you're a solicitor, whether you're a family member or a friend, anyone with a concern for that person's well-being can make an application for NCAT. The forms are on their website, so you can access those forms there. So anyone can do that. It isn't necessary that it's a social worker. It isn't necessary that it's someone in particular. It is anyone. So service provider, most definitely.
Okay. Well, thank you, Jessica. Just before we finish, we have some upcoming, again, this is a series of law for community workers. We do have some upcoming webinars, some actually today. Later today, we have Working Together, Your Story, Legal Support and Disability Royal Commission. 26th of August, the National Redress Screen 2 years on. And Wednesday, the 9th of September, Energy and Water Issues Help During Difficult Times. And please feel free to register for those free webinars through the link provided on the screen. Well, I will leave it there. Thank you, Jess. I certainly learned a lot today, and everyone else did as well. So thank you for your time.
Thanks.
Again, we would appreciate if you would fill in the feedback forms. That would be great as well. And there's nothing further. I think we'll leave it there. So thank you again.
Thanks, everyone.